First off, I want to thank Town & Country for asking me again to present. I'm used to doing these in person. I think the Money Conference 3 or 4 times, and I've done several presentations at various locations for Town & Country. And so you may have seen this this presentation before. Sometimes it does take a couple times for these things to kind of sink in. So consider it an extra free consultation for you. And we have a lot of ground to cover. Normally I would have an open floor and people would be welcome to ask me questions and interject. We don't have that ability today. So I did want to emphasize that at the end of this presentation, you'll see my contact information, including my email address. So we're just going to kind of get this started. And I'm going to kind of lay the groundwork first. I'm just going to have a checklist here of things that we talk about. So a couple things that on our checklist here are the things that we typically talk about, the type of stuff that I'm asked to consult on. We've got healthcare directives, which kind of encapsulates living wills, healthcare powers of attorney. We have financial powers of attorney. We talk about people's current assets, how they're titled, beneficiary designations, how those are set up, things like life insurance and retirement accounts. We talk about trusts versus wills and which documents are going to be more appropriate. We assess things like gift and estate taxes, if that applies to you, and we'll talk a little bit about that today. We talk about annual gifting from parents to children and other relatives. We talk about marital gift planning, and that's usually in the context of estate taxes. And we also consider ancillary procedures. And what that means is we're talking about out-of-state assets, people who own real estate in multiple states or assets in multiple states and administering those after your death. We talk about debts and expenses and how those are going to be dealt with either during your lifetime or after death. Talk about business arrangements for those folks in Maine who have businesses. We'll talk about long-term care arrangements, things like nursing home care, in-home care, how to protect your assets from long-term care. We talk about burial and cremation and funeral arrangements and charitable gifting. So safe to say, we kind of talk about all the things that are important in your lifetime. So we are going to start and really focus on the documents that are necessary for people as they work through their family's dynamics. Today, I'm going to start with advanced healthcare directives and planning for incapacity. So these are the documents that are most important if you lose your capacity, you're not able to make decisions for yourself and communicate with your doctors or your healthcare providers. So what is an advanced healthcare directive? It is a combination of a healthcare power of attorney and a living will. You probably hear those terms all the time. Why do we do them? We do it to make your wishes known. It gives you peace of mind to know that, at the end of life, your wishes are going to be adhered to, and hopefully your loved ones will follow those. The other thing is if you don't tell your loved ones what you want in the event of an illness, injury, or incapacity, they don't really know, what decisions to make. And that can be harder on your family members to have to make those decisions with no knowledge of what you would do in that situation. Don't assume that at the end of life or middle of life that you're going to have the ability to speak. And this is people, as young as 18, 19, we do them for kids headed off to college right up to, 90s and hundreds. So it's important at all stages to have these types of documents. And one of the bigger reasons people like to do these is to avoid family disputes. A lot of times there's more than one person in your family that wants to make decisions for you. Kids can have power struggles over who's going to be the one to make the call, who's going to be talking to doctors, who's going to be taking mom and dad to appointments, things like that. So how do we do an advanced healthcare directive? Well, we typically do them for almost every client that comes to us for a will or a trust. They're super easy for us to do. It's kind of like a throw-in, a really valuable throw-in that most estate planning attorneys will do for you. But there are free statutory directives that are out there. The Maine Hospitals Association has put those together. You can Google Maine Advanced Healthcare Directive. It would be the first link that pops up. You can go to your doctor's office. You can go to the hospital. You can ask for them. You can fill them out on your own. And you can sign them in front of at least 2 witnesses, but preferably a notary as well. And it's right on the document. Most of it is, fill in the blank or checking boxes. So you can take care of that piece on your own without any cost. And these are really important documents. So the types of decisions that you're going to make in the Advanced Healthcare Directive, first and foremost, you're going to designate the agent or the alternate agents that you want to make these decisions when the time comes. You're also going to decide when that decision making takes effect. It can take effect kind of immediately. You can give your spouse or your kids, for example, the ability to talk to your doctors, and you waive HIPAA. A lot of people aren't necessarily comfortable with that, but just rest assured that it's not taking away your own ability to make your own decisions. It's kind of like opening the door a little bit and letting your spouse or your children or other individuals in on that, the ability to make those decisions. Or you might decide that you only want it to take effect when your doctor has declared you to be incapacitated. We talk about things like end-of-life decisions, and these typically come into play if you're in a terminal condition or an irreversible coma or a persistent vegetative state. In other words, if you have no quality of life, you're not able to communicate your decisions. The questions are, would you want to be kept alive artificially? Would you want to have tube feeding? Would you want artificial defibrillation? Those types of things. And if you know that you would want to be taken off those artificial supports, you can make that decision for yourself in this directive, instead of making your spouse or your kids make that decision for you. My clients always love to refer this as, the pulling the plug decision. You can also decide whether, you want to have pain relief, and how extensive, type of comfort care do you want, as you reach hospice type care or end stage care. And then you can also decide, about do not resuscitate orders. And the one thing I want to emphasize is that a lot of people think a living will or a healthcare directive is a do not resuscitate order. And that's not the case. A do not resuscitate order is usually standalone. It's usually something that is signed by you in the presence of your physician, and your physician signs as well. And the line that I like to draw for you is, if you sign a do not resuscitate order with your doctor, if you're out working in your garden and your heart stops and they find that or know about that do not resuscitate order, they will not bring you back, even if you could be back working in that garden the next day. And that's oftentimes confused with not wanting to be kept alive artificially, which is the decisions you make in the Advanced Healthcare Directive. Some other things that we do in this document is you might identify your primary care physician, just to make it clear who the individual is that you've seen for your primary care. We talk about organ donation and whether you want, to have a cadaver donation or just donation for transplant therapy, research, education. You can get very clear. Some clients, most clients are more general in just their desire to give if anything is viable. And then we make funeral and burial instructions. And a lot of people, you'd be amazed how many spouses I talk to, families I talk to, where they have never talked about it. In their 80s, it's really funny when it happens, but they have no idea what they want done. And imagine you died tomorrow and nobody has any idea what you want done. And some people care to put more detailed instructions. Some people like to keep it general, but this is the document that you would do it in, not your last will and testament. So now we're going to move on. Advanced Healthcare Directive is one of the easier documents to get and do. It's a no-brainer. And the one thing I want to point out before I move on is that if you don't have an Advanced Healthcare Directive, your family, if we get to a stage where you're not able to make medical decisions for yourself, your family members are going to have to likely pursue guardianship through the probate court. And that can cost thousands of dollars. I do it regularly. Vast majority of them, it's a minimum of $2,500 to $3,000. Because you have to go to have a full hearing, and there's all sorts of proceedings that need to happen. So the healthcare directive really is worth its weight in gold. Take my word for it. Go get one and take care of it. Now we're going to move on to durable financial powers of attorney. And a lot of you will have heard this, at some point in TV or modern culture. It's a document where one person, the principal, appoints another person, the agent, to act on his or her behalf. So really, if I'm making out a power of attorney, I'm appointing somebody else to manage my affairs. So as an example for me, I've appointed my wife to be able to make decisions financially solely in her decision-making if I'm unable to help her. And if not her, I've designated somebody else. Why do we do it? Well, you have to provide legal authority to your loved ones in the event that you become injured, ill, or disabled. Just because you're married does not give your spouse the ability to do anything you could do for yourself. There's tons of things. And I like to always give the example, my wife tries to go and call Verizon Wireless to change our cell phone plan, and they won't speak to her. So imagine that comes into play with my retirement account or my life insurance policy or real estate that I might own in just my name. It can become a real headache for your spouse or your kids to be able to handle those decisions for you. You also do it because, as I mentioned just before, it's far less expensive and time consuming than the alternatives, things like conservatorships. And like I mentioned, it's thousands of dollars for your family to get authority if you don't have a power of attorney. And last but not least, we can prevent power struggles between family members. I mean, the nice thing about this is you get to appoint who you think is best to handle your finances, as opposed to your family trying to figure out, who's going to do it. So how do we go about doing it? Well, there are more strict drafting requirements around powers of attorney in Maine than the Advanced Healthcare Directive. It's highly, highly recommended that you have an attorney draft this document. You can't necessarily pull one off a LegalZoom or Google Maine power of attorney. I've looked at, even recently, I had a client that pulled one off the internet and it wasn't valid because it doesn't contain the language that is required under Maine law to make it valid. And the last thing you want when you lose capacity is for your family to be left with, a couple sheets of paper that don't do anything. And take my word for it, because I've reviewed these for some area banks, frequently, and you'd be amazed how many of them I've had to tell the bank are not valid and they should not allow the person to act on behalf of the principal. One of the big things on execution is it does need to be signed in front of 2 witnesses and preferably a notary as well. So, if you do happen to find one, at the very least, make sure it's witnessed by 2 witnesses and a notary. They're not very expensive documents to have an attorney prepare. Like I said, usually this is another document that we draft for almost every client that comes in to do a will or a trust, because they're no-brainers and they save everybody a ton of money. So the concerns that we hear most often about powers of attorney, people are concerned about the dangers of the unlimited grant of authority, agents acting in their own best interest. For example, if I'm my mother's power of attorney, I would have the ability to go to her bank and pull money out and spend it on myself. So there's always the concern of what they call breaches of fiduciary duty and theft and financial exploitation. And this document, to be quite honest, is one of the documents that gets taken advantage of the most when it comes to estate planning. You might also have conflicts between the principal and the agent. So if I'm my mother's power of attorney and she's starting to lose her ability to handle her affairs, there might be a conflict as to when is it okay for me to, kind of take the reins and protect her. So we commonly get called in to resolve those conflicts between our clients and their children, or children and their parents. Mismanagement and or neglect by the agent. You might appoint somebody that just doesn't do what they're supposed to do. They might forget to pay your bills. They might forget to pay the taxes. They might not monitor your investments. There's any number of things that an agent under a power of attorney can fail to do. Usually, we can explain to clients all the protections and safeguards that are there. First and foremost, you don't name people you don't trust. Most people are going to name their spouse or their children that they trust to handle these affairs and not take advantage of them. That's not always the case. I certainly have clients that name someone else other than who you'd expect because they just don't trust them. You can draft what are called springing powers of attorney. And these are powers of attorney that spring into effect on a certain contingency happening. For example, your power of attorney might say, my agent shall have the power and authority to act for me only after my physician has declared me to be incapacitated, or after my spouse has been declared to be incapacitated. We don't do these most of the time because typically it's hard to get doctors to sign those types of certifications. And typically it can take a lot of time to do that. The biggest safeguard that I've got is 1 and 3 here. You protect your copies. You don't give anybody a copy of it. And unless your agent has a copy of the power of attorney, they can't act for you. So naming people you trust, protecting your copies of the documents is always the best way to safeguard and protect yourself. So those are the 2 documents that come into play during your lifetime. And again, everybody should have a financial power of attorney and an advanced healthcare directive. If for those of you who have kids that will be going off to college or are at college, I would recommend that before you send them off, that you get them to sign an advanced healthcare directive and a power of attorney, naming you, their parents, as the agents. Because once you're 18, parents don't have any rights to healthcare records. They don't have any rights to go and deal with anything financially or medically for the kids. And we've actually had to deal with some pretty serious situations where kids have mental health crises at college, or have accidents, or studying abroad, having issues there. So it is really a no-brainer. And again, they're not very expensive, and you can save yourself a lot of time and effort by making sure your kids have those. So now we're going to move on to, what most people are familiar with, the last will and testament, and we're going to talk a little bit about trusts as well. But what is a last will and testament? Well, most of us are aware that it's a document that allows an individual, usually called the testator or the testatrix, to state his or her wishes regarding the distribution of assets after death, as well as naming the individual. More commonly, most people know of them as executors, but we call them personal representatives now. And that's the person that's going to administer your affairs after death. Why do we do it? Well, if you don't have one, the state essentially writes one for you. They call that intestacy proceedings. The state directs where your assets go if you don't have a will. And a lot of people are sometimes surprised that it doesn't automatically send everything to your spouse. I've had 2 of those just in the last week where, a spouse died and hadn't done a will, and there were some assets that were solely in the spouse's name. And believe it or not, if you have a blended family, or you have, children of previous marriages, the surviving spouse doesn't take 100%. So you do want to make sure you have a will to protect those rights. The will can be the main document in your estate plan. It typically governs all assets that you own solely in your name when you die. You can limit or eliminate family conflicts or disputes by identifying specific wishes. You might, want to give the family farm to John Boy and leave, money to his brother Tommy. So those are the types of disputes you can resolve by making sure you have a properly drafted document. You can reduce or eliminate estate taxes. I'm not going to belabor this one, but suffice to say, if you have an estate that's worth several $1 million or more, you definitely should be counseled as to the current estate tax climate in Maine and federally. It doesn't necessarily just affect, the Steinbrenners and the Vanderbilts and all the uber wealthy families that you hear about. So make sure that you talk to counsel if you have, larger estates. And for younger couples, it's really important. This is why most people in their 20s, 30s, come to see me, is because they're concerned about their minor children and who's going to be guardian for them, and how are the assets going to be managed for the benefit of minor children. And so a lot of my clients tend to be people in their 30s, whether it's friends of mine or people that I've met and acquaintances that are having kids. And one of the first things we talk about is who's going to take the kids, how long do we want to hold assets in trust for the kids, who's going to be the trustee. Those are the things that are on the front of their mind. So how do we do a last will and testament? Well, Maine is a state that recognizes what are called holographic wills. They are very specific wills in that they have to be in the handwriting of the testator. They can't be typed up. They can't be written out by somebody else. They have to be in your handwriting and signed by you. The holographic wills do not necessarily need to be witnessed or notarized. But Maine does recognize them. I'm not recommending that. I just had one, recently in the last couple of weeks that was holographic, and it is likely going to work just fine. But more often than not, the holographic wills written on the napkins and written on the white line paper are going to cause more issues than if you had just gone and done it right the first time, and they can be far more expensive to administer. Wills typically prepared by attorneys. And when I say they're prepared by attorneys, I would highly recommend that you find someone that specializes or has a lot of experience in trusts and estates. And that's not just because I'm a trust and estates attorney. It's because I have seen wills that have been prepared by, general practitioners or attorneys who don't typically, do wills. And I can tell you that, more often than not, when I get involved in litigation, it's typically around a will that has been prepared by someone who is not experienced in that area. And it can be far more expensive. And that's not to say that general practitioners can't do them. And people who don't specialize in them. But if you have any complexity to your estate, I would recommend that you meet with a trust and estates attorney. Maine does have a will that's what they call the statutory form, and that you can find it in Maine law. You can go down to your local probate register of probate and purchase one, I think, for a couple dollars, and you can fill it out. You can sign it in front of 2 witnesses, and it would be effective. The caution that I would have to people doing their own wills or printing something off LegalZoom is that you don't get the benefit of counsel of certain things that may be more complex. And I can tell you what I hear the most is, I just want a simple will. And I can tell you that, at least 5 out of 10 of those times, or half of those times, I guess I'd say, those people don't have a simple estate. There is something that needs to be done to provide for a beneficiary or a specific type of asset, and it just goes outside the realm of what a simple will would be. As far as execution of them, if it's a holographic will, again, you just need to sign it. If it's typed up in any fashion or a filled out statutory form, you have to sign it at least in front of 2 witnesses, and preferably a notary as well. 2 witnesses and a notary. That would be the best way to do it. So now we're going to talk a little bit about the contents of last wills and testament and what goes in them. First thing I like to deal with is my arch nemesis, tangible property. Things like coin collections and jewelry, cars, boats, Hummel figurines. I can tell you that, one of the biggest litigation fights that I got into were 2 sisters fighting over a Hummel figurine collection. And we had to get counsel involved, and it costs all sorts of money. So the one thing probate judges don't like to deal with are fights over stuff. So you can take and make distributions of tangible property. A lot of times we'll do a memorandum or a list, so the client can do that on their own, but we take care of those first. Then we talk about specific gifts and bequests and devises, and those might come in the form of charitable bequests, like giving $10,000 to an organization. I've listed a couple there just by way of example. Sometimes I have clients that want to give, a specific amount to a friend or a specific amount to one of their children to equalize gifts that were made to other children. There's any number of reasons why specific gifts of specific monetary amounts would come into play for a client. Then, we start talking about the residuary of an estate. We talk about, where's the rest going to go? And a lot of times it might involve talks about testamentary trusts. There might be minor children involved. There might be disabled beneficiaries involved, people that, are receiving SSI, supplemental security income, or main care, or other types of public benefits. And we need to do specific planning around those. Again, I'm not going to belabor that. I could spend an hour on planning for people that are disabled alone. We oftentimes, if there's a taxable estate, we have to make some provisions in the wills for estate taxes and how we can reduce or eliminate those. And then we talk about the residuary estate distribution. Now, this should be in every will, no matter who you are, where you just say, I give the rest, residue, and remainder of my estate. So whatever else is left, the final bucket is going to be distributed to the following people. And most of the time, it's pretty simple. People will say that it goes to their spouse or to their kids in equal shares. We'll talk about whether, if one of the kids predeceases the parent, do we want their share to go down to their kids, the grandkids? Do we want to do a percentage? Sometimes people treat their children disproportionately because of a number of reasons. But there has to be a residuary distribution in every testamentary document, every will or trust, just to make sure that everything kicks out at the end. And with that in mind, you should also make sure that there's a contingency distribution. In other words, if all of your beneficiaries are deceased, and I call this my sinking party boat example, if you can imagine on my slide there that that's your family and you're all going down together, it's such a lovely thought. But I like to provide that if that were to happen, would everything go to charities? Would everything go to your closest heirs? Would everything go to your nieces and nephew? So we talk about, what happens if everybody's gone. And then you get to a point and give powers and authorities to your trustees and your personal representatives. So you get to choose who's going to administer your estate, who's going to administer assets for beneficiaries if you've left assets to beneficiaries in trusts. And again, the discussion of whether a trust is appropriate or not, we're going to cover today, but that's always going to be something you should talk to counsel about. Most people who don't practice trusts and estates, would have no idea whether a trust is appropriate or not. And then, as I mentioned with, parents of minor children or parents of disabled children, you get to nominate, who you would want to handle that role if you pass away. And we have a lot of clients who either have disabled children that are minors, but we also have a lot of adult parents who are guardians for their adult disabled children. And if they pass away, you have to appoint who's going to take over in that role. So now we're going to get into trust. And I love to put my favorite quote up there that I hear all the time when clients come in and say, I need a trust because my neighbor told me so, or because I saw it on TV, or, I saw it at a town and country presentation, some attorney was talking about it. And the bottom line is not everybody needs a trust. There are a lot of circumstances where people, a trust is appropriate. We're going to talk about those now so you can have a little bit better idea of that. But first, I want people to know what it is. It's the same as a will. It's a document. It's an agreement that allows a third party, the trustee, to hold assets on behalf of a beneficiary or beneficiaries. And it's pursuant to the wishes of what we call a settlor or a grantor. That's the person that creates the trust. So just to recap, if I want to create a trust, I'm the settlor. I appoint who the beneficiaries are, and I appoint who the trustee is that I want to manage it for them. So why do we do them? Well, a lot of people like to do it to avoid probate. I have a slide at the end that kind of summarizes probate in a nutshell, but a lot of people want to keep things private. And, a lot of people don't realize that probate is a public, you can read public documents, online, and a lot of people want their wealth or their affairs to be private. So we do it to avoid probate. A lot of people, believe it or not, have disabled children. I draft supplemental needs trusts all the time for disabled individuals. I did a speech, fortunately for the Autism Society for Maine, and I couldn't tell you how many of those people just hadn't even had time to think about, what it would mean if they weren't around for their disabled child. So if you have a beneficiary who's disabled, I put that at the top of your list. We talk about trust for minor beneficiaries. So to give you an example, I have a 5 and a 7-year-old. And if my wife and I were to pass away together, there's certainly more there if we pass away than now, but there would be assets that have to be managed for them. And I wouldn't want them to get it until they're, maybe 30 or 35. And clients differ as to when they want assets to kind of pour out and be available. And at the same time, we can provide to pay for their health or their education or their maintenance and support during that time, but it's somebody else that would be calling the shots. I mentioned privacy already. The other reason people, do trust is because the assets in trust can be more readily available to the family members after death. If you have assets that are solely in your name, again, you have to go through probate. It's a little bit of a process. Maine is a lot more efficient than almost any other state that I've dealt with, and I've dealt with a lot of states. Our probate process is really efficient. Typically you can get someone appointed and hit the ground running within a couple of weeks after you pass away. So I'm not as concerned about probate avoidance and having assets readily available as some other states like Massachusetts, Florida, some of these other states that take much longer to get things going. If you have real estate in multiple states, and we get that a lot, we got a lot of snowbirds that go down to Florida or the Carolinas, those people definitely should have a trust. If you have real estate in multiple states, you want to have the asset that's outside of Maine at least in the trust, because you don't want to have to probate the estate in multiple states. I can give you an example of an estate that I had in Florida that had a trailer that was worth $20,000. Now, on a little lot down there, and it would have cost us $15,000 to probate it or more, and the family just decided to walk away from it because it was just going to cost more money to deal with it than it was worth. So if you're one of those people and you've got assets in other states, you definitely should be looking to have a trust drafted, if nothing else, just to hold that asset. We also talk to clients about family camps, and you might be one of them. If you've got a camp on Sebago or Thompson Lake or a ski cabin, I mean, those are the types of things that families want to try to put into trust, or family LLCs, limited liability companies, to try to provide for ongoing management and administration of it over time. And so if you're one of those families that has a multi-generational camp, and it's the list of beneficiaries is just growing, that's something you should consider. How do we do it? I can't recommend enough that you do it with estate planning counsel. You can't. The trusts I've seen people draft on their own, I've never seen a good one. Trusts drafted by counsel who don't do them regularly, I can't say that I've ever really seen too many good ones there either. So just make sure you're dealing with someone that knows what they're doing. And I say that out of love, because I wouldn't try to do any real estate closings. I wouldn't try to do bankruptcy proceedings. And so just because you're an attorney doesn't mean you know everything about every area of law. So trust considerations, do you really need the trust? The things that I want you guys to think about is there is a cost of drafting and funding a trust. So while it might be, cheaper or more efficient on the back end in some situations, it's also sometimes going to be more expensive on the front end to draft them. And I wish I could give you a number as far as what every trust costs to draft, but it does vary depending on the complexity and the things that go into them. You have to think about the practicality of funding a trust, meaning moving assets and retitling them in the name of the trust. I mean, if you don't do that, then the trust might as well, not matter at all, because you have to retitle the real estate or retitle accounts in the name of the trust. And for some clients, the practicality of that is just not worth it. They'd rather just let the kids go through probate and deal with it there, and let them deal with it. So think about that. The other thing you want to think about with trusts is they typically have their own accountings. Your trustee has to account for every cent. As I'm sure you can imagine, we deal with litigation all the time on trusts that are mismanaged and money is not invested wisely. Money is disappears. So the accounting for trusts can be a little bit more complex. In some cases, especially with irrevocable trusts and trusts that you can't revoke or change or pull back, there will be separate tax filings, separate from your individual income tax returns. There are also, in the cases of a lot of trustees, trustee fees. Not all the time. A lot of people think that trusts are only for people that have a lot of money. That's not the case. I've seen trusts that are have as much as $15,000 in them if there's a specific reason we're dealing with that. But usually for larger trusts that are in excess of, $250,000, $500,000 or more, it's not uncommon to have a corporate or professional trustee like a bank or a trust company that are appointed as the trustees. And they do charge fees, very similar to, a financial advisor or, your fees that you get hit on your 401ks or your IRA accounts. So you want to think about, our trustee fee is going to be too high. And then trust management by what I would call laymen, people who really have no idea what a trust is, and they get named as a trustee. There's a danger there because, they might do something wrong. The example I like to give is there was a trust that a woman made for her daughter, 8-year-old daughter, and the woman died and named her sister as the trustee. Lovely woman, and really cared for her niece. But over the, 13 years, I think it was, until the daughter turned 21, she didn't invest the money. She just stuck it in a savings account and didn't earn anything on it. So by the time the daughter turned 21, she ended up suing the aunt because the aunt owed her a duty, but just didn't know about it. So you want to be really cautious about naming trustees who are not familiar or sophisticated enough to handle those responsibilities. And then when it comes to trust, there are some unanticipated problems. Banks are sometimes reluctant to make loans on properties held in trusts, even if the document says that the trust can take out loans. There are property tax relief programs available, like homestead exemptions and veterans exemptions and things like that. And sometimes towns, there are certain trusts that, will result in you losing your homestead exemption. So you always want to be cautious of those things before you set up a trust. So what is the deal with probate? At a very basic level, it consists of collecting assets of a decedent, someone who's died, paying and settling their debts and liabilities, and then distributing the remaining assets to the beneficiaries pursuant to the will or pursuant to the intestacy distribution if there isn't a will. That's it in a nutshell. Most estates in Maine are going to be handled at a pretty low cost. Again, it's hard to give estimates, but most estates, there's probate filing fees and legal fees, typically in the, I'd say $1,500 to $5,000 range, for most simple garden variety estates. But probate provides a structured procedure for the settlement of your affairs, whether it's, finishing out your businesses, paying your funeral expenses, paying your final debts, and then making sure that the beneficiaries get the money that you've left to them. Now, there are 10 steps, and I want everybody just to kind of have a brief rundown of what probate entails when it comes to process, because it's all driven by process. The first thing that happens is that the original will, the actual signed will and a death certificate gets filed with the probate court, and fees are paid to the probate court in order to initiate probate. And they're typically filed with a petition or an application to the court to appoint a personal representative. Most of the estates that I administer, it's done informally, which means we file it, the court receives it, and they respond and send back to us what are called the letters of authority. That's step 3. The court essentially puts a stamp and seal on something saying that John has been appointed as personal representative of his mother's estate. And then John can proceed forth and he can close accounts, he can pay bills, he can sell real estate, he can administer the assets. After John gets appointed as personal representative, the interested parties receive a notice. So there's no secrets when it comes to probate. They're required to send out notices to all of the heirs and all of the devisees, the people who are listed in the will to receive something. So John can't get away with just doing whatever he wants without anybody knowing about it. He has to serve notice on everybody. And then John has to take an inventory of the estate, and that might involve listing out all the real estate. It might involve, taking account of any tangible property, whether it's artwork, equipment, guns, jewelry, all those things have to be inventoried and written down. Same with any accounts that are there. And the one thing I'll point out here is that a lot of people get confused about, what assets go through probate. There are assets like life insurance or retirement accounts, that will go to the beneficiaries of the beneficiary designation outside of probate. Those are called non-probate assets. So a lot of people will set up those types of assets to go directly to their beneficiaries without having to go through probate. Probate and the inventory is only going to relate to those assets that were solely titled in the name of the decedent on their date of death without any joint owner or any beneficiary on the account. So after we've taken inventory of the estate, the personal representative is going to identify and settle any claims or debts against the estate. This may involve credit cards, medical bills. There might be a main care, what they call a Medicaid claim against the estate if the person was receiving main care benefits. If required, the personal representative has to file final income tax returns for the decedent or estate tax returns if the estate is large enough. Then, after all the expenses, debts, taxes have been paid, the personal representatives typically send out an accounting or are required to account to all the heirs and the devisees, and then they propose a plan of distribution. So what that means is they're going to say, this is what I had when I started the estate, this is what I spent, this is what I have left, and this is what I propose to distribute to all of you. And we typically, in most estates, not necessarily estates that have just one beneficiary, but if there are multiple beneficiaries, we typically require everybody to sign off on it and say, yes, I agree, the personal representative did what they were supposed to do. And then after everybody's signed off, or once we've gotten final agreement, we'll distribute the assets, and then we close the estate. So it's a pretty procedural process, and it's fairly easy. In most estates, you always hear horror stories, and people are always worried about probate. But I can tell you, having done this for 12 or 13 years and having administered hundreds and hundreds of estates, I've only had, a handful of estates that get really heated. I've never gone to trial over an estate. We've gone to mediations and all sorts of settlement stages, but most people don't want to incur the cost of going through a full trial when it comes to an estate. So in Maine, you can typically get away with a very straightforward probate estate and go from there. So there are a couple things that I wanted to hit upon because I did get a list of all the questions you guys have asked, and most of them I think I probably have answered in my presentation, but I wanted to clarify for some people that estate planning is a little bit different than financial planning. Financial planning is typically reserved for, retirement planning and, life insurance planning and making sure your stocks and your investments and all those things are lined up. You'd want to see a financial advisor or a financial planner to do those types of assessments. Estate planning planning is really about, preserving and sheltering those assets and making sure they go the way they're supposed to go, and everything flows the right way, and making sure you have the right parties involved. A lot of people brought up questions about, whether a will has to be professionally designed. Again, I'm just going to stress that, yes, it really should. No, it doesn't necessarily cost an arm and a leg. I can give you kind of estimates of what I've seen in my time for doing a simple will, power of attorney, and healthcare directive. I mean, you really shouldn't necessarily, if you're paying less than $300 to $500, you really should assess who you're working with, because a lot of times, they might not be putting the effort in to identifying, what your wishes are. But most of the simple estate plans that I do will typically run from $600 to $1,000 for individuals and spouses. And then they go up from there depending on what level of planning you have. If you've got trusts, if you've got estate taxes and all those things, you can expect to probably spend a couple $1,000s or more, because there's just more planning involved. So that should give you a rough idea of estate planning. I stress it for everybody. I do planning from, like I said, everybody from 18-year-olds to, all the way up. And it's really not something you should wait around until you're 80 or 90 to do. And if you did, go out and do it tomorrow. We really don't know when we're going to have any, accidents, illnesses, deaths. And unfortunately, in my line of work, I see all of it. And I can tell you that unfortunately life catches up to us at all ages. So make sure you do the planning. You definitely don't necessarily have to do it with me, but I do stress that you do it with trust and estates attorneys. My contact information is on the screen. If you happen to be in another area of Maine that's, way out of the way, and you want some recommendations on attorneys in the area to work with, I'm happy to make some recommendations. But like I said, if I didn't get to any of your questions, feel free to shoot me an email. It's right there on the bottom left of the screen, and I'm always pretty good about getting back to people. As long as it's not individual questions about your own personal affairs, which would go on giving you legal advice. And if that's the case, then you can certainly make an appointment and talk with me. So Linda, I think you had a couple questions that we had that you had pulled that you wanted me to answer from the list. Is that right?
I do have a couple of questions. Miles, thank you. That was very helpful. A lot of information and a lot for all of us to think about. And I do have a couple of other questions that I think you maybe touched on a little bit, but if you could elaborate on a little bit. Long-term care. What are some of the best options? And I know there's a lot. I, for one, right now, personally, am dealing with an elderly mother who is 94 years old and is in assisted living and in and out of the hospital. We don't know what the future holds for her. And one thing I'm very grateful for, that about 16, 17 years ago, my brothers and I came together and took out a long-term care policy for her. So, who knows that we're going to live to 94 or 95? And, it's really helping our family to be able to have that policy in place now, that we're able to help her and, make these transitional times, comfortable for her. So I would, what are some of the best options for people?
Well, yeah, you definitely named one of them. Long-term care insurance is something people should at least look into and know about. There are agents that specialize in long-term care insurance, but the reality is that the vast majority of my clients, either don't have the resources to pay for long-term care insurance, because if you don't get it really early in life, it can be very expensive. Typically the insurance market kind of missed when they initially long-term care insurance became a thing, they kind of missed the market. And so a lot of people stopped offering them, even the bigger box insurance agencies. So the big things that we talk to clients about is that you have to know that if you don't do any planning for long-term care and you get to the point where you need assisted living, residential care, nursing home care, in-home care, there's no insurance that pays for that. Medicare doesn't cover that. Your gap insurance doesn't cover that. So you're going to start private paying for that. And that can be as expensive as $4,000 to $7,000 a month for assisted living. It can be $8,000 to $12,000 a month for nursing care. I just had a client that I'm kind of regularly involved with who was having in-home 24/7 care. and that was, running, $5,000 to $7,000 a week for in-home private 24/7 nursing care. So it's extremely expensive. And so if you think about your assets and you get to that point, your kids are going to be, or your family is going to be blowing through your assets to pay for your care. And so one of the biggest things I have clients, schedule appointments to meet with me about is, okay, what do we do to protect the camp? What do we do to protect the house or this cash that we've got stowed away? And the bottom line is most clients, don't like the answer because it involves typically giving up control, giving up ownership, either transferring assets outright to family members or putting them into special trusts that you don't have control over. And I can literally do an hour or more on, the various other strategies that are available to trying to shelter assets from long-term care costs. But if you can think about your assets and you have anything like family farms, family camps, those things can get fouled up in a hurry if the matriarch or the patriarch gets sick and go into long-term care, because unless you spend down below $10,000, there are no benefits that are going to pay for that. Once you're below $10,000, Medicaid we call it main care in Maine care will pick that up. But if you have more than $10,000 worth of assets, you can expect to be spending every last cent on your long-term care, either during your lifetime or after your death in probate. And that includes your primary residence. It includes any of your other properties that you might have, Linda.
So are there any, what are some of the ways that people can protect their assets?
Yeah, one of the most popular ways, my clients typically come down to is they create an irrevocable trust. It's a very specialized type of Medicaid compliant trust that has to carry specific terms. And one of the big things that clients don't love about it is it makes it so it's not available to them. In other words, if I'm, my spouse and I want to try to protect the family camp, we might put it into the Hunt Family Irrevocable Trust. We might name my two children as the trustees and the beneficiaries, but I no longer own it. I can't control it. I can't change my mind about it. But the only way for us to protect that asset is to get it out of our names well in advance of a need for long-term care. And currently that look back period is 5 years. If you don't give an asset away at least 5 years before having to apply for main care, you will get denied, and they will assess a penalty period based on the gift of the asset. So it's something, if you're considering or concerned about, it's something you should talk to your attorney about, sooner than later. If you're getting up into your 70s, 80s, 90s, it becomes more risky every day to do that type of planning. So the people I'm seeing the most that talk to me about that are people that are just about retiring. They've kind of identified what they're going to need to carry them through the rest of their life and their budget, for their regular expenses. A lot of times, in retirement, people are starting to slow down their travel and their expenditures. So that's kind of the time that you either make a decision to do something or you don't. And I see the whole spectrum, and I'm not, there are some attorneys that will pressure clients into doing it, but I have the full spectrum of clients that don't want to do any planning and they're totally fine with spending through all their assets. If my dad was on here and he's an estate planning attorney too, he'd say, we're going to spend it all. And I'm like, that's your right. And that's my client's right to do that. But then on the other hand, I've got clients that want to protect every last cent. They don't like the idea of having to, spend everything. And so those are the people that we like to give options to. We like to make it as flexible for them as we can. We like to protect them as much as we can, because make no mistake about it, usually that's not planning to benefit the client. It's planning to benefit their kids or their other family members, because, the client's the one taking all the risk. They're the ones that are moving assets, whether it's their house, their savings, their money, their camp out of their name, and they're putting a lot of faith in their kids and their family members to do that. So it's not a decision that should be taken lightly. If you ever have the experience of working with me, you'll know that I counsel heavily in it to make sure people really, really want to do it and understand all the risks, because I don't want anybody coming back and saying, I didn't know that I couldn't do this anymore. So that's probably the biggest planning people are doing in advance, Linda. There's also another stage of planning, which they call the crisis planning. That's when people are like, going into the nursing home tomorrow, is there anything that we can do to try to protect any of these assets? That's not really an area of law that, I can advise on it, and I typically counsel on it, but usually the strategies that are involved there, I don't get involved with. There are other attorneys. Some of the more notable ones are Patty Nelson Reed, Law Office, or Tracy Nail. Some of these people who are elder law attorneys, and they really specialize in main care applications and helping people do, special gifting and annuity purchases. And it gets complex. We've talked about maybe doing another session, and I could cover those in a little more detail in there, Linda. But suffice it to say, there's two different levels of long-term care planning. There's, long-term care planning, and there's crisis long-term care planning. And they happen at different times of people's lives.
Mm-hmm. Yeah, sounds like there's a lot to take into consideration. One other question we have is, is there a way to prepare an estate to be able to be passed down to your children? What's the best way to look at that, and also still be able to stay in your home while you're making that plan for your estate?
Yeah, so that kind of still goes to what we were just talking about with long-term care planning. But I mean, what I see most commonly is people are comfortable moving their homes that are debt-free into an irrevocable trust. With their, maybe their children, if they're usually their adult children at that point, as the trustees, and then the kids give back what are called a life lease, which is the parents' right to live in the property for their lifetime, exclusively. And typically we put some restrictions along, that the kids aren't, able to sell it without, all the trustees agreeing. And typically they'd have to sell it with the life lease involved. So when it comes to long-term care planning, that's what I think is protecting clients the most, is if they put it into an irrevocable trust, because then it's protected from their kids' divorces, their kids' deaths, their kids' liabilities, so long as the parents are living. But if we're kind of moving away from the long-term care aspect of it, and you want to maintain control over your property, typically either, letting the property pass through your will, letting it pass through a revocable, just a normal living trust is fine. A lot of times people now will ask about transfer on death deeds, which Maine just started recognizing in September of last year. And a transfer on death deed is something that you can record. It doesn't actually transfer property until after you die. And it's doesn't have a lot of necessarily support from the real estate members of the bar, but it is legal now to have a transfer on death deed. That's something that you can consider, because that would pass the property outside of probate. So those are the big ways to pass assets on to kids. And certainly you don't want to consider leaving your, putting your house in your minor children's name or anything like that. But when you start talking about adult children, it's either one will or trust or a transfer with a deed.
So if I haven't taken care of any of these kinds of legal matters and planning, what's the one best thing to start with? Is it a will? Is that the first? I mean, if there's like one thing you really ought to have, and just to be able to, plan ahead or to be able to protect your family, what's the one document somebody should try and take care of and move on sooner than later?
I mean, to be perfectly honest, the will, the power of attorney, and the healthcare directive, I kind of think of them all together, because anybody that comes in my door, those are the estate planning 101 documents that everybody should have. And they, the power of attorney and the healthcare directive are so easy to have. People are always focused on the will, but then they realize that the power of attorney is actually way more important to them during their lifetime. So I'd say those documents, kind of taken as one, are most important. But if it were me, I mean, if I'm talking about the client, the power of attorney and the healthcare directives are the most important, because for most people, the Maine laws pass assets the way they would want. They go to your spouse and kids, and for most people, that's generally how they want their assets to go. So even if you don't have a will, we can get there. But if you don't have a power of attorney and a healthcare directive, you're talking about potentially thousands of dollars of legal fees that your family is going to have to incur, and a court proceeding that your family members are going to have to incur. So I think probably the powers of attorney are the most important, both for medical and financial.
Mm-hmm. Well, and in my personal recent experiences, without those documents, the medical people, if your loved one ends up in the hospital, if they can't give them permission to talk to you, if you've not completed those documents, you can't get any information. And same,
you may be up a creek without a paddle, so to speak. And
yeah,
the bottom line is, we can sometimes get there. And I think doctors are, especially in the case of a spouse or children, they will sometimes be a little bit more lax, but not always. And, not every family is a Leave It to Beaver family anymore, where, you've got a spouse and you've got two kids, a boy and a girl. It's just not like that anymore. We've got a lot of blended families. We have a lot of domestic partners who have no, legal, documents saying that they're married. I mean, if you're unmarried, you should definitely do your planning, because your domestic partner has no rights necessarily over, at least not over certain aspects of your life. So having these documents could be crucial for that.
Well, thank you very much. Lots of great information, and we appreciate it. Thank you for joining us, and have a great evening.